welcome from behind the flowers. I'm András Patyi, the Vice President of the Hungarian Supreme Court, as we call it, the Curia, and also Professor of Administrative Law at National University of Public Service. I think I am presiding, or I am the moderator of a real Visegrad 4 panel, as we have presenters from the Visegrad countries, from the Czech Republic, from Slovakia, and from Poland, and the Hungarian moderator is in the front. I do not want to take off any of the time from our lecturers, our presenters, so I'd like to give the floor to Associate Professor Dr. David Sehnálek from Masaryk University, Czech Republic, Brno. Professor, the floor is yours.
Is it on? Can you hear me? It looks like, yes. So, good afternoon, ladies and gentlemen. Our European legal space is specific in that it houses several Supreme Courts which overlap in their decision-making. The mutual relations among these courts are not satisfactorily established. They are no part of any clear hierarchy that would make it possible to resolve or avoid potential conflicts among these courts. And the circle includes, of course, the Court of Justice, the European Court of Human Rights, and constitutional courts of member states of the European Union. And I would like to shed some light on the rules governing the mutual relationships among these courts. In particular, I would like to determine to what extent are these courts mutually bound by the decisions and interpretative conclusions. Another objective is to present the approach of the Czech Constitutional Court towards the European Court of Human Rights and the Court of Justice and their decisions. Well, and we lawyers naturally assume that there must be some kind of hierarchy in the judiciary. It is crucial to determine who will have the last word in a matter he's engaged in. From this point of view, I forgot to, since I don't see it, I forgot to work with my presentation. Sorry for that. From this point of view, the European space represents an environment characterized by uncertainty. The courts I have mentioned are well aware of this, and they usually try to avoid any mutual contradictions in their decisions. And the Czech Constitutional Court is no exception in this respect. And in my first part, I would like to focus on normative approach to the problem, and I will try to lay out some general systemic principles. And the reason is simple. Usually the question of how one court influences another is reduced to the nature of the ensuing decision, whether it is binding, whether it serves as a precedent. So to put it simply, a judicial decision is always a decision no matter which court have issued it. And my impression is, at least when it comes to the Czech Republic, Czech case law, and Czech scientific literature, that it tends to be neglected that these considerations are only relevant in the framework of a single legal system. And here comes the problem. The situation is somewhat more complicated when it comes to the Strasbourg Court, the Luxembourg Court, and Constitutional Court of the Czech Republic. Decisions of these courts, decisions rendered by these courts represent parts of various legal systems. And these legal systems may define what effects these judgments may have and whether or not they are binding. And this is sometimes disregarded in literature and in practice of the Czech Constitutional Court. So judicial decisions are often treated as a general category, regardless of which court have issued them. And I believe that such an approach is quite simplistic. The reason is that our courts interpret public international law, national law, and the European Union law. So as a result, the question of nature and of effects and binding nature of judicial decisions must be therefore addressed in view of mutual links among these separate legal systems. Interpretation of international law is governed by rules comprised in this very law. Vienna Convention has been mentioned already in the morning. In contrast, its national effects are basically mediated by domestic laws. In the Czech Republic, they are set by the Article 10 of the Czech Constitution. You can see the text here on the slide. This provision of our constitution considers some international treaties directly applicable in the Czech law, and international treaties covered by this provision become a part of the Czech law, which is to be interpreted and applied by Czech courts. However, the interpretation of these treaties is, of course, autonomous on the Czech law. And international treaties on the protection of human rights form a special category, sui generis in the Czech legal system. They are considered as a part of Czech constitutional order and therefore serve as a benchmark in assessing the constitutionality of ordinary laws, of statutes. This, however, doesn't change anything about the original nature, so they are still considered to be a part of international law, and the mechanism of the interpretation is in no way affected. And the Czech constitution governs the relationship between national and international law, but it deals only with national effects of international treaties. It remains silent about decisions issued by international organizations and their bodies. So the nature and effects of such decisions can be established and derived from the very international treaty, which created the given international organization, and are again mediated through the national law. So the courts are then bound by the given international treaty and the way it has been interpreted by the authority of the given international organization. And this mechanism partly applies in the case of the European Convention and the European Court of Human Rights. The European Convention assumes that the Czech Republic, as a contracting party of this international treaty, will follow the judgments of the European Court of Human Rights in proceedings to which it was a party. Nevertheless, this convention does not require member states and their courts in this respect to respect the judgments of the European Court of Human Rights in general. It does, in other words, in all cases, thus also in those proceedings in which Czech Republic was not involved. So it therefore cannot be concluded that the European Convention established directly the European Court of Human Rights general power to provide binding, and we can say also a correct interpretation of its text, which would have to be followed generally by courts of the contracting parties. There is no normative basis for such a statement. Well, this is theory and legal regulation. The approach, I don't have it here, I guess, maybe. I'm sorry, I'm not used to look behind my back when presenting something. Yeah, this is it. So this is the theory and legal regulation. But the practice, the approach of the doctrine and of the practice of the Czech Republic and of the Czech Constitutional Court is significantly different. The prevailing opinion of the Czech legal doctrine is that the Czech Republic is de facto, whatever that means, obliged to comply even with decisions rendered in proceedings concerning other states. So law is not only what the European Convention say, but also how it is interpreted by the European Court of Human Rights. Well, and the truth is that such an obligation may be set by a national law, but we don't have it in the Czech legal order. And this approach can be demonstrated on a case. You can see a part of it on this slide, this case concerned home childbirth. And here the Czech Constitutional Court cited Professor Wildhaber, who in his speech at a conference organized by the Czech Constitutional Court was speaking about the binding or erga omnes effect of judgments of the Strasbourg Court. And the speech was in this judgment used in support of general binding nature of the European Court of Human Rights decisions in the Czech legal order, and it was also used as a clear confirmation that such an approach is the only correct. Well, quite funny is, and here we come to dissenting opinions and their relevance, Quite funny thing is that one of the dissenting judges noted in his opinion that Professor Wildhaber devoted the vast majority of his speech to the harsh criticism against the European Court of Human Rights. This criticism concerned mainly the activism of this court. Professor criticized the fact that the subsidiary role is often overlooked by this court. So Professor was not defending the erga omnes effect, but he was actually speaking against it. But this was not reflected by the Czech Constitutional Court, not at all. The situation is different when it comes to EU law. EU law is autonomous in relation to both national and international law. It is supranational law, and it determines its effects which it should have in member states. And it also determines its own rules of interpretation. And from this viewpoint, the Article 10 of the Czech Constitution is practically irrelevant. Consequently, the effects of acts taken by EU institutions, and thus also decisions of the Court of Justice, are specified by the EU law and not by national law, which is a significant difference compared to the European Convention. The practical consequence is that the space for interpretation of EU law by national courts of the member states is substantially restricted. It is the Court of Justice who is the one to provide correct and binding interpretation, and the legal basis is in Article 19 of the Treaty on European Union, the first one, not the functioning one, and you can see this provision here on my slide. So this provision is construed as giving this body an exclusive position in interpreting European Union law. Interpretation provided by this court is therefore binding on European Union member states and the judiciary. And judgments of this court are deemed to be quasi-presidential. So they do not serve as a source of law, and they are not binding erga omnes. In view of the nature of EU law, they are directly and without any mediation binding on national courts as to the way they interpret the law. It could rightly be argued, of course, that this is a position which reflects only the stance of the Court of Justice itself. Some constitutional courts accept this position, these principles of application of EU law. Some do it only partially, as is, for example, the case of the Czech Constitutional Court. And the viewpoint of national constitutional courts is quite understandable. They accentuate the derivative nature of the European Union and of its powers, and these could only be derived from national laws and within their limits, which are comprised primarily in the respective national constitutions. And I, of course, also accept this position, but only to a certain extent. I believe that there is a substantial difference between the founding member states of the European Union and accession countries, as is Hungary, Slovakia, and the Czech Republic. The founders were presented with a fait accompli by the Court of Justice. Acceding countries, on the other hand, knew the circumstances full well and decided to accept the acquis communautaire to its full extent, thus including the way the Court of Justice defines the characteristics of EU law. It is therefore, according to my view, for the judiciary to influence and restrict through the case law the lawmaker's decision to make the country a part of the EU, as these international organizations operate according to the case law of the Court of Justice. I haven't touched one problem yet, and that's the status of the EU Charter in the Czech law. According to some decisions of the Czech Constitutional Court, it might be a part of the Czech constitutional order and thus a reference framework, as is the European Convention. But there are also some decisions which imply that it is not. And even in those decisions in which the EU Charter is considered by the Czech Constitutional Court to form the reference framework in the Czech Republic, the Constitutional Court usually hesitates to use the Charter directly. So the charter is then used through the Constitution. In such a case, Article 1 of the Constitution, you can see it right here on my presentation, is used. According to this provision, the Czech Republic is to oblige its international commitments. And this provision is often used in combination with other provisions, especially of the Czech Charter. And this is how, for example, the Constitutional Court was able to incorporate into our constitutional order the protection of consumer, which is not protected by Czech Constitution. And it was incorporated via this provision and via the provision regulated or protecting the right to a fair trial. There are, however, certain problems with this solution, and I would like to demonstrate them on a very recent case of our Czech Constitutional Court. It's a case which is less than 2 months old. And this case concerned a consumer credit contract which provided for interest rate at a 140%. And according to the Czech legislation, the consumer could defend himself by raising an objection of invalidity, but he had to do it in within 3 years since the commencement of the contract. Well, and unfortunately in this case, this period had already passed, so it was not possible for a consumer to defend himself in a way which was expected by EU law and by EU directives on consumer protection. So the Common Court asked the Constitutional Court for the repeal of this provision, and it based its submission on, in particular, on the right to a fair trial. And to put it simply, since that's not important, Czech Constitutional Court dismissed the petition. It stated that the provision should not be applied. Therefore, the conditions, according to the Czech Constitution, for its annulment were not met. And the reason that it should not be applied lies in the EU law, which, through a directive plus related case law of the Court of Justice, which was dealing with or interpreting the principle of effectiveness, prohibits such an application of such a provision, which, of course, from the viewpoint of EU law, is absolutely a perfect solution, and I agree with it. Well, on the first side, that's it. That's everything. It's an innocent, unimportant decision, which didn't end it well for the consumer at hand. But there is more behind. And as I said already, according to the Czech Constitutional Court, it's a famous bankruptcy judgment, human rights treaties are part of Czech constitutional order, and therefore they are at the level of constitution. And according to our constitution, if there is a conflict between a law and a constitution, the ordinary court is obliged, under Article 95 of our constitution, to refer the matter to the Constitutional Court. And the Czech Constitutional Court extends this duty of common courts also to international treaties, and thus also to the EU Charter and European Union law. So that means that common court does not have a competence to apply directly such an international treaty protecting human rights. It cannot do it by its own. It has to submit the thing to the Constitutional Court. And as I said, this competence was set not by the Constitution, but by a famous decision of the Czech Constitutional Court, famous in our country, of course, which is known as bankruptcy judgment. Well, and the core of the problem here is that this works well with European Convention. However, as I said, the Constitutional Court treats the EU law and its standards of human rights protection as any other international treaty. So I have mentioned all these specifics, but they do not apply in the case law of our Constitutional Court. So it doesn't treat it as an autonomous EU law with all its particularities of application, of principles of application, but as an extension of our constitution on the basis of international law. So to put it again simply, the Common Court, when referred to the Constitutional Court, did exactly what the Czech Constitutional Court expected to do it. On the other hand, there is a settled case law of the Court of Justice, according to which the Common Court is obliged to apply the EU law directly. It has to give it the precedence, and there is no necessity to ask the Constitutional Court or any other higher court, and there is no need to wait until the provision, the conflicting provision of the Czech law is repealed. So the Common Court had, in this case, two conflicting options. It was either to comply with the Czech constitutional law or to comply with the EU law. And it quite logically chose the first one and was rejected by the Czech Constitutional Court. And our Constitutional Court was fully aware of this conflict. Of course, you cannot see it in a decision itself, but the thing was highly discussed. Some argued that the provision of the Czech statute has to be repealed, which would confirm the bankruptcy judgment. It would also confirm the status of the EU law as a part of reference framework in the Czech Republic. And any other solution would threaten the bankruptcy judgment and change the settled law of the Constitutional Court. On the contrary, some of the judges argued that this is not necessary, as this provision has to be amended by the Czech legislator, and the Constitutional Court has no power to intervene. Plus, the problem really does not exist, as the Common Court already has quite clear instructions by the EU law and by the Court of Justice. And in the end, this decision, rather unimportant decision, is quite significant, as it questions the validity of the bankruptcy judgment and of the basic principles how our constitutional order is functioning. And funny thing is that from the viewpoint of the EU law, this question doesn't even touches the human rights protection, whereas from the perspective of the Constitutional Court, it is a matter of fundamental rights as freedoms, as it has incorporated the consumer protection by the EU law into our constitutional order in its previous decisions. Well, and that's it. Some people believe that this might change the status quo in the Czech Republic. I don't think so. I think that the bankruptcy judgment and our positions the position of the Constitutional Court is still the law, but it really is an interesting question, since the burden lies on a Common Court, and it has then make a decisions whether to comply with EU law or with our constitutional order. So to conclude my presentation, Czech Constitutional Court doesn't distinguish between the nature of EU law and international law, European Convention in particular, and this is also true when it comes to judgments of the Court of Justice and European Court of Human Rights. In the set of my 30 decisions, as well as in any other decision, there was no such distinction. Well, in case of the European Convention and European Court of Human Rights, the real practice is that our Constitutional Court simply accepts these solutions, these decisions as they are, and doesn't use the room which was left by the European Convention, doesn't reflect the fact that this system has subsidiary nature and doesn't work with the doctrine of margin appreciation. I have mentioned that case concerning the home childbirth. Case Ternovsky versus Hungary was used almost mechanically in this case, despite the fact that there was a significant place for a discussion and for questioning the approach which was adopted by the European Court of Human Rights. So that's the position towards the European Court of Human Rights. There is no dialogue there as you know, this case law of this court is simply accepted and used in a similar manner as previous case law of the Constitutional Court. In case of the Court of Justice, the Czech Constitutional Court tries to systematically avoid any discussion or conflict, usually simply by pretending that the case law of the Court of Justice concerning the principles of application does not affect it. It acts as this case law does not exist, does not touch our Constitutional Court. So in the end, it's quite the opposite in the way it should be in the Czech Republic. The case law of the European Court of Human Rights is unquestionably accepted to the extent the European Court of Human Rights and European Convention itself does not require. And by contrast, the case law of the Court of Justice, which relates to constitutional matters in the Czech Republic, is partly, de facto, completely ignored, despite the fact that it must be accepted. So I would say, in the end, our Constitutional Court is quite submissive when it comes to the European Court of Human Rights. Well, and it is still waiting for a clear coming out when it comes to its orientation in case of the Court of Justice. Thank you.